Neither the district attorney, the judge, or my client actually had a co-defendant, his attorney. No one else was aware of this case. No one else was aware that this law had changed. No one else was aware that 18 to 20-year-olds were being issued licenses to carry in the state of Texas. And to be clear, this case doesn't say that you have to have a license to carry in order to carry in the state of Texas.
We are the Armed Attorneys. We're talking big things when it comes to 18, 19, 20-year-old carry, talking Supreme Court, what's going on in the state of Iowa, and some stuff happening here in Texas. Leslie's going to get up on a soapbox for a little bit. But before we begin, show your support for the Second Amendment by hitting that like button. And Leslie Cross, great to see you.
Yeah, thanks for having me.
Yeah, but we have a big decision coming out of the United States Supreme Court out of Minnesota. If you wanted to check out this case, it's Worth v. Jackson. This is the District Court 021 CV 01348. And this related to Minnesota passed a law prohibiting the carrying of firearms by 18, 19, 20-year-olds. They were immediately sued by everybody, including the Firearms Policy Coalition. They did a fantastic job here. The District Court found this unconstitutional, and let's start with that order, and then we'll talk about what happened at the Supreme Court. And so what was the kind of crux of the order there?
Yeah, absolutely. No, it was some great language from the court, and what it said essentially is that the plaintiff's motion for summary judgment was granted in part. The judgment was granted to plaintiffs on the issue of whether Minnesota statute violated the rights of the individual plaintiffs and otherwise qualified 18 to 20-year-old members of certain organizations to keep and bear arms as guaranteed by the Second and 14th Amendment of the United States Constitution. The court declares that the Minnesota statute requirement that a person must be at least 21 years of age to receive a permit to publicly carry a handgun in Minnesota violates the rights of individuals 18 to 20 years old to keep and bear arms as protected by the Second Amendment and the 14th Amendment. Defendants are enjoined from enforcing the 21-year minimum age requirement in the Minnesota statute against the individual plaintiffs and otherwise qualified 18 to 20-year-olds.
Yeah, and they had some other motions there. They got denied. We don't need to cover that stuff. But essentially, we see, all right, we have this Minnesota court saying, hey, this infringes on the Second Amendment right, the right to keep and bear arms, 18, 19, 20-year-olds. These are part of the people. The government couldn't justify this prohibition under our New York State Rifle and Pistol Association v. Bruin standard. This is not something that the founders would have regulated, as I'm using that term in modern parlance, at the time of the adoption of the Second Amendment in 1791. And so, all right, unconstitutional. The state of Minnesota, they appealed this up to the Eighth Circuit Court of Appeals. They denied reviewing this thing, and then it finally went up to the United States Supreme Court. And this is where, sometimes when the Supreme Court doesn't step in, it benefits us. Rare. I've heard a lot of alarm bells going off lately, but the Supreme Court denied petition and didn't, effectively, what does that mean?
So basically, the Supreme Court said that they're not going to review this. This isn't a case that they feel like they need to get involved in. And it basically made it to where this underlying case stands, essentially.
Yeah, so 18, 19, 20-year-olds. Now, in the interim, there was this thing was put on pause while this thing was being appealed. That's going to go away once the Supreme Court sends this back down to the district court. And so that's forthcoming. I mean, that's happening. And it's an amazing step in the right direction, especially, you see big gun control groups like Gifford Center or Every Town for Gun Safety. They're pushing all these raise the age bills all over the United States. It's simply not constitutional. And this isn't the first time we've kind of seen this. This is the first time the Supreme Court has reviewed it. But we have circuits all over the United States that have said, hey, guess what? These prohibitions are no good.
Yeah, I believe they said this was the eighth time that this has happened. So this is the eighth, not the Eighth Circuit, but the Eighth Circuit Court that actually has made this decision. So that's kind of interesting.
Yeah. All right. So, two other things we wanted to go over. What's going on in the state of Iowa? The governor just signed into Law House File 924, and this goes into effect. I mean, this went into effect July the 1st, if you're watching this after the fact, but it goes into effect July the 1st. And what did this bill do?
It basically did the same thing. So it said that it made it legal for 18 to 20-year-olds to own and carry firearms, essentially what the court did in Minnesota.
And so, all right, the evidence is mounting. Our 18, 19, 20-year-olds, when they say otherwise qualified, I think that's important to note. because maybe there are restrictions if you have felony conviction, these other things. The courts aren't addressing those issues. Obviously, we see those challenges going on, but we're talking about responsible, otherwise qualified 18, 19, and 20-year-olds. Could they carry generally in public? Well, in Iowa, effective July the 1st, yeah. Could they get a license or permit to carry? Well, that's where the Texas case comes in. And we got this. This is the Andrews v. McCraw case.
Yeah.
You're familiar with this one.
I am. I actually just handled one of these cases. Unfortunately, my client did not have a license to carry. And let me be clear, it's my understanding that in the state of Texas, the state is issuing 18 to 20-year-olds licenses to carry.
Yep.
So how this case would have played out had my client actually had a license to carry, that's a different story. But I had a 19-year-old client who recently was arrested and charged with unlawful carrying for carrying an otherwise lawfully owned and possessed firearm. So we made the argument of the Andrews v. McCraw case again to the court, and unfortunately, the state ended up dismissing our case before we actually got to have a hearing on the writ that I wrote. I was very excited to actually go and fight this and argue and hopefully have some sort of case law come of it, but they did agree to dismiss the case. But, obviously in the state of Texas, can you carry if you're 18 to 20-year-old? I don't know. It's unclear.
Yeah, I would say yes, but you're going to have these crummy DAs twist this as much as they can, because what that case essentially said was they sued the state of Texas. They sued a handful of DAs. They said, hey, guess what? We have two different laws at play here. Our unlawful carry of a handgun, just our Texas constitutional carry law, and our license to carry law under our government code. They said, hey, to the extent that these laws infringe on 18, 19, and 20-year-olds' ability to carry generally in public, the state of Texas, your officers, your agents, and people working in concert with you, you cannot enforce these laws. Well, right. If the Harris County District Attorney isn't acting in concert with the state of Texas, I mean, they are the state of Texas. It seems like, what are we doing here? And that's what Leslie was arguing. Very good brief from Leslie there. But it's a good reminder, but where do we get, case law? Hey, somebody gets convicted. The court makes findings of fact and conclusions of law. And then, hey, guess what? We have this law to rely on. That's what we had in the McCraw case. We have lots of justified self-defenders out there, cases where folks are dismissed, they're acquitted. Those don't have any precedential value. You can't rely on these cases and other cases or cite them because, hey, guess what? They haven't. This isn't law. This was just the outcome up by the jury. And so, it's tough and it's hard that you're only basing our law based off of the losers. I don't like that.
Yeah. And what was interesting to me was that neither the district attorney, the judge, or my client actually had a co-defendant, his attorney. No one else was aware of this case. No one else was aware that this law had changed. No one else was aware that 18 to 20-year-olds were being issued licenses to carry in the state of Texas. And to be clear, this case doesn't say that you have to have a license to carry in order to carry in the state of Texas. It says that anyone, as long as they lawfully can otherwise carry, as Richard was talking about, so, not a convicted felon or anything like that. No one else was aware of this. So I was having to try to educate everyone and had to give them the case so that they could go review it. And the court or the district attorney's office position was actually that this was just something.
It's persuasive.
Yes. Thank you.
No. They said it was persuasive.
They said it was persuasive. And so their position was that this was a persuasive case.
And I'd say generally they're right. When a federal district court makes a finding, conclusion of law, right? They say, hey, here's a state of a rule of law. Generally, yeah, that's true. It is persuasive on state courts. However, this is an injunction. This isn't this wasn't a, hey, this is the state of the law. Courts, do with this what you will. This was a, hey, state of Texas, you are prohibited from doing this. That's not persuasive.
Not at all. Not at all persuasive. So my client was arrested, had to go to jail, had to post a bond, had to get an attorney, had to go to multiple court dates before this ultimately was resolved. And, obviously for the benefit of my client, I'm very happy that it was resolved and it was dismissed and, he's done with this. But I do wish that we could have had the hearing on my writ just to see kind of what the judge would have held. And, maybe we could have gotten a better idea of what the status of this law is.
And that brings us to, kind of an issue that comes up with this. All right, We have the court ordering the state of Texas not to enforce these 18, 19, 20-year-old prohibitions. Their agents, officers, people working in active concert with them. Well, guess what? That doesn't change the black and white text that's in our, let's say, penal code or our government code. Because if you look at our unlawful carry statute, it still says under the age of 21. You still look at our eligibility criteria for a license to carry in the black and white, 21. Well, all right. Even though those have been modified by this injunction, we have a good effort. This is HB 2470 by Representative Wes Verdell, and it would basically codify the existing status of the law just to remove all this ambiguity.
Which would be very helpful. I mean, then it would be very clear that 18, 19, 20-year-olds can carry a firearm lawfully, and you're not going to have people out there who think that they're following the law, and then all of a sudden, click, click, you're in handcuffs and you're going to jail and your day's ruined when your understanding is that you were doing nothing wrong.
Yeah, can you imagine? And I bet this has happened. It hasn't come in through our office, but I bet there is an 18, 19, or 20-year-old license to carry holder out there who has been arrested. And they say, you got to be 21.
Probably.
I bet it's happened just because, and you know what, cops have a hard job. You know, I don't like them when they're prosecuting my clients, but, you know, they aren't staying up to date on all this stuff.
They don't. You know, they have legislative updates, but those legislative updates aren't mandatory, is my understanding, and they can do them whenever.
Yeah, they come usually every 2 years.
They do, but I mean, you know, you have that 2-year period. So, for example, the law is about to change again this year. So there's some officers who are just taking the legislative update from the last legislative session. So they're not even up to date on those laws, which is concerning.
Yeah, so part-time job, educating the prosecutor about the state of the law, as Leslie has talked about. But you see, all right, big win in Minnesota. Thank you, Supreme Court, for upholding that strike down. Good on Iowa. In Texas, we need to get our act together. So if you want to help this cause out, call your state representative. Let them know, hey, guess what? HB 2470 by Verdell. Support that stuff. We need to make our law clear. People are going to get mad over this term, but it really is just a cleanup. Just make it unambiguous. Clarify what's happening here. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And always leave your questions in the comment section down below. And until next time, worthy armed returns.